Hello, good morning. I'm Jane Fielding. I'm head of the Employment, Labour and Equalities team here at Gowling WLG, and I'm very pleased to welcome you to this second webinar in our series of 4, which we're doing this week and next to replace our usual in-person annual update seminar. We really hoped by now we'd be able to welcome you back into the offices in person, but sadly that's not the case. So we're now pinning our hopes on being able to do that in June for our mid-year review. But today the topic is COVID-19 testing at work. We're beginning to get questions from clients about this subject as people look to how best they can get back into the workplace and get their businesses running as normal again with minimum disruption. So we thought it was a timely opportunity to pull together the key issues that we've been looking at for clients in this presentation. I would ask you though to bear in mind that this is a single element testing of a constantly evolving picture as the science evolves and the government policy across various departments evolves to respond to that. So this is how it is today. In the future, it may be a little bit different, the factors that you need to consider and the balance that you give to those. But Alice Lockney, who's a senior associate in our team, is going to be covering all the employment law aspects of COVID testing in the workplace. There's an inevitable overlap to some extent with health and safety, and so she will touch briefly on that, but the pure health and safety aspects and the public health obligation aspects of testing are outside the scope of this morning's talk. So Alice is going to present for about 25 minutes. We've left time at the end of that for some questions. If you do want to ask a question, then please use the Q&A function. You should find it in the middle at the bottom of your Zoom screen. You can also use that if you do have any technical problems, and Lucy Strong, who is helping us on the tech side of things today, will hopefully be able to sort you out. Hopefully it will all run smoothly though, and nobody will need to use that. Before I hand over to Alice though, we thought it would be interesting to do a quick poll to see who is already using testing for their employees and workers, and particularly in what sectors that might be happening. So Lucy is going to open the poll now, and it won't take you very long to fill it in. There's only 3 questions and possibly only 1, depending what your answer to the first one is. But she will leave that running for a few minutes before she closes it. And before we go on to the questions at the end of Alice's presentation, we'll come back to it, have a look at the results and share those with you. So I will now hand over to Alice for her presentation.
Thank you, Jane, and good morning, everyone. Thank you very much for joining this webinar on COVID-19 workplace testing. I'm really looking forward to seeing the results of the poll later on, and I'm conscious that amongst this group, we're likely to have organisations at a whole range of stages, from those who might be weighing up whether to do COVID testing at all, through to those who already have a system in place and want to check that what they're doing is legally compliant, or might be here to pick up some tips for dealing with tricky issues that have come up so far. So bearing that in mind, I've tried to include something for everyone. So over the next half an hour or so, we'll cover, firstly, should you introduce testing at all, and what are the legal constraints? For those with a testing system already in place, this might be relevant if you're thinking of expanding testing to cover different groups, or if you're thinking about whether to make testing compulsory rather than voluntary. Next, if you do introduce testing, how can you keep your legal risk to a minimum? I'll share 5 key questions that all employers should be thinking about. Thirdly, what are your obligations as an employer when the test results come in? And last, a bonus section on vaccines. So can you make employees tell you if they've had a COVID vaccine, or even go one step further and require employees or maybe job applicants to be vaccinated? So should you introduce testing at all? Well, there's been plenty of publicity around the limitations of COVID testing, particularly the rapid result lateral flow tests that many employers are considering using. Testing's also expensive, and if you get lots of employees testing positive, you might have issues with gaps in the workforce as people have to self-isolate. But there are some big names, a few of whom are on the slide there, who've invested significant sums in building their own testing facilities, and more are either partnering with the government's asymptomatic testing pilots or procuring their own private tests to use on employees. So why are those employers doing it? I've put some of the most common reason on the slides. It will often come down to wanting to protect employees' health and safety, but that won't be the same for every organisation or even every part of the workforce. And it sounds obvious, but it's really important to stand back and give this some proper thought before introducing or expanding any testing programme. Not least because that question will be core to the analysis of many of the legal risks that we'll discuss today. So my first recommendation of the day is to really scrutinise any proposal to introduce testing. What will it actually achieve given the nature of your workforce, the other protective measures you have in place, and how accurate the tests are that you're looking to use? So moving on to the potential legal constraints on testing. We'll focus on data protection first, and then move on to look at unfair dismissal and discrimination as we consider mandatory testing. It's key to have data protection in mind from the outset, as this is the one legal constraint that could stop you from doing testing at all, even on a voluntary basis. Information about whether or not an individual has COVID-19 is obviously health data, so it's unlawful to process it unless 1, you have a lawful basis, 2, you meet an extra condition under the GDPR in recognition of the fact that that data is particularly sensitive, and 3, you have the right documents in place. If you don't comply with these requirements, the Information Commissioner's Office or ICO can take enforcement action, including issuing fines. So how do you comply? Well, taking the lawful basis first, the 3 that are most likely to apply, along with their GDPR references, are on the slide. The ICO has published some guidance on for employers considering doing testing, and they've stated that for most employers, the relevant basis for processing testing information will be legitimate interests. But for some public sector bodies carrying out their public functions, they can rely on their own specific condition. It's also possible, though, that processing could be justified on the basis of compliance with a legal obligation, if you're carrying out testing in order to meet your legal obligations towards employees' health and safety. Interestingly, the ICO hasn't referred to this one in their online guidance, but the guidance is subject to updates, and the ICO has said that organisations need to make their own assessments, not just blindly rely on what's on the website. And this should be based on individual circumstances, so I don't think you can discount this when you're thinking about this one. So just delving a little more deeply into the legitimate interest condition. If you're relying on this, you need to go through a 3-step process. This type of analysis will be familiar to many of you as HR professionals who may have had to consider the justification defence for potential indirect discrimination claims. The stages are, number 1, what's the legitimate interest? And this is where your assessment of why you're actually doing COVID testing is key. Number 2, is processing the data, so carrying out testing or looking at the results, necessary to achieve that? And number 3, is processing still justified when balanced against the intrusion on the individual's rights and freedoms? So assuming you have a lawful basis for processing, the next step is to identify which of the special category conditions applies. Again, the ICO has helpfully published guidance on the 2 conditions it considers are most likely to apply here. Firstly, the employment condition, which should apply to most employers who are carrying out testing to protect the health and safety of their staff. But it's unlikely to apply where testing is introduced more in order to provide customer or employee reassurance rather than protecting safety as such. There's also the public health condition, which might apply in the case of an employer who's looking to support efforts to stem the spread of the virus in general by testing and reporting results to public health authorities. So taking a couple of examples, in the case of employees working in a busy manufacturing environment, the nature of the work might mean that they can't work from home and that there will inevitably be some close contact between employees despite social distancing measures. In that case, the employer is likely to have a lawful basis for carrying out regular testing to identify asymptomatic cases, either on the basis of a legal obligation, i.e. discharging their duty to protect the health and safety of staff by reducing workplace transmission, or on the basis that testing is necessary for the legitimate interest of safeguarding employees' health and safety. And there's no less privacy intrusive way to do this, as the other COVID secure measures don't go far enough given the nature of the workplace. Similarly, testing in this scenario is likely to be in compliance with the organisation's employer health and safety obligations, therefore meeting the employment special category condition. The intrusion on the individual's privacy can be minimised by limiting access to the test results to those who need to know and storing the results for no longer than is necessary. In contrast, though, in a professional services environment, an employer might want to introduce day one testing as a way to persuade employees to come back to the office where they've been working remotely through lockdown. Besides the likely employee relations backlash and employment law issues with requiring people to come into work when they could work from home, I think that at the moment it would be very difficult to justify testing on this basis under data protection law. It's hard to say that a one-off test would just discharge an employer's health and safety duties, and it's unlikely to be legitimate to use testing in these circumstances when the far less privacy intrusive approach is to allow employees to continue working from home if the office isn't COVID secure. I think we're quite a long way off seeing the balance tip, but it's potentially one to come back to as we hopefully start to see cases decrease and more workplaces opening up. So just to round off on data protection then, in order to comply with your data protection obligations, you'll need to provide employees with a privacy notice. So this could be a standalone privacy notice for testing provided to the employees before the test takes place, or it could be your standard existing employee privacy notice that's been updated to cover this specifically. It's also recommended to use the ICO's template impact assessment and the legitimate interest assessment too if you're relying on that as your lawful basis for processing. Both of these will help you to show your reasoning in the event of a challenge. So moving on, if you're considering mandatory testing, there are additional considerations to take into account in terms of legal risk. I would flag at this point that mandatory testing is relatively unusual. Even for those working in clinical roles in the NHS, for example, testing is voluntary unless you have symptoms. If you do want to make testing mandatory, you'll need to consider, firstly, discrimination. So are there any groups that would be adversely impacted by the requirement to undergo COVID testing? Disability is the one that immediately springs to mind, taking into account those with physical disabilities that make taking the sample difficult or more painful, for example, but also those with mental health conditions that amount to disabilities, for whom this might, for example, cause heightened anxiety. Those individuals will be entitled to reasonable adjustments to the testing policy, and a blanket policy with no flexibility at all is highly unlikely to be justified as a proportionate measure, given the potential alternative safety measures available and the limitations of testing that I've already mentioned. Also, don't forget unfair dismissal rights for employees with more than 2 years service. In some circumstances, it might be reasonable to instruct employees to submit to a COVID test, maybe, for example, if they're dealing with vulnerable people as part of their role, and you've assessed that this is a critical part of your health and safety measures. But to go as far as implementing a disciplinary sanction or a dismissal for a refusal to take a test should only be taken in the most extreme circumstances. And I'd say that in general, there's a really high risk of a successful unfair dismissal claim, due to the number of reasons that people might be reluctant to undertake tests and the range of other measures that employers can and should be taking to protect the health and safety of staff and members of the public in any event. For both of these risks, I think the key is going to be to listen carefully to employees who express concerns or who refuse to undertake tests so that you can make a balanced decision. It's likely to be much more effective to concentrate on engaging with employees and unions and getting them on board with voluntary testing rather than looking to impose a mandatory approach. In terms of how you do that, in some circumstances, consultation will be compulsory prior to introducing a testing programme. For example, if this is covered by a recognition agreement that you have in place with the trade union. But in any case, the government guidance on employer-run testing programmes is that it's strongly advised to consult before introducing COVID testing. And I would echo that, not least because it will help you to get staff on board and spot any potential logistical issues before they arise. In terms of the reaction that I think you're likely to get during consultation, the TUC position on workplace testing is that it's a valuable tool in protecting workers' safety, so it's probably quite likely to be welcomed. But during consultation and when advising their members, I think unions are likely to be particularly interested in some of the issues we're about to come on to, including pay, time off, and ensuring testing isn't used to dilute other COVID secure measures employers should have in place. So there's a summary on the slide there, and we're now going to move on to how to successfully implement a testing programme. And there are 5 key questions all employers should think about when designing their policy. Firstly, who will be taking the samples and analysing and processing the results? Will this be outsourced in full to a third-party provider, or will any element of it be carried out by your own staff or the employees themselves? If staff are going to take their own samples or read their own results, there are a few specific considerations to have in mind. Firstly, results might be less accurate, so that needs to factor into your risk assessment and balancing exercise. Does this undermine your reason for doing testing at all? Secondly, staff with certain disabilities may find it more difficult to take their own sample and might require an adjusted process or extra support. And thirdly, perhaps cynically, do you trust employees to provide you with accurate results, or do you want to build in a review by an objective person? This might be the case, for example, if you have a history of people coming into work when they should be self-isolating. And it will also tie into the topic of whether you will pay employees for the self-isolation period over and above any entitlement to statutory sick pay. So that's who. Now, what type of test are you going to use? The key considerations to take into account are cost, speed of results. So if you want to use the results on point of entry to the workplace, it's not going to be particularly helpful to have to wait 12 or 24 hours for lab results to be returned. Specificity or number of false positives. So a high number of false positives will lead to more employees unnecessarily self-isolating. And the flip side, number of false negatives or sensitivity, because a high number of false negatives could lead to less asymptomatic cases being captured and potentially a greater spread of COVID in the workplace. So you might require more frequent testing in order for this to be an effective strategy. The effectiveness of the test for your particular purpose is a key factor in whether collecting test results is justified under data protection and discrimination law. So you need to do your research into this, ensure you can justify the decision. For example, if your stated reason is the protection of health and safety of staff, but you're planning to just do a one-off test with a low sensitivity rate on the return to the workforce, will this really add anything over and above your other COVID secure measures? The evidence on effectiveness is constantly evolving, as are the options in terms of cost and speed. So this will really need to be an ongoing analysis. So we've covered who and what. Now, where will testing take place? With the rise of self-administered rapid results tests, more employers are doing tests on site rather than sending employees off to specific testing labs. Have you thought, though, about how you will manage the practical aspects of this, like social distancing amongst staff waiting for a test, how you'll address any accessibility issues with the site to avoid placing disabled workers at a disadvantage, and whether you may need to stagger start times? That leads us on to when will testing take place, and will employees be paid for that time? If testing is going to take place outside of work hours, for example, if employees are going to have to turn up for a shift an hour early, have you thought about the impact on employees with childcare responsibilities or who would otherwise find it difficult to amend their hours? Is there a less discriminatory way of doing this? If you were on a witness stand in an employment tribunal, could you really put your hand on your heart and say there was no way you could have done testing in work hours? The time taken in waiting for and having the test is also likely to amount to working time for the purposes of national minimum wage and working time regulations. So employees who are paid on or close to national minimum wage must be paid for the testing and waiting time, and that also needs to be factored into daily and weekly rest calculations to avoid inadvertently breaching the working time regs. In terms of those who are on a higher hourly rate or an annual salary who aren't in national minimum wage territory, there's no obligation to pay for testing time unless your contract says so, and it would be worth just double checking what the time off for medical appointments clause, if you have one, says. But refusing to pay in any event is likely to make it much more difficult to get employees on board with voluntary testing, particularly if this is a regular thing. So you need to weigh this up really carefully. So that's who, what, where, when, and now how frequently will testing be carried out? Well, it's a bit like a DBS check in that a COVID test is out of date as soon as you've taken it. And there's not yet a clinically defined number of times that an individual should be tested within any given time frame. Some high-risk workplaces are doing daily testing, but it's more common to see testing done 2 or 3 times a week, and that's the model used in the government asymptomatic testing pilot. The government guidance for employers on workplace testing suggests taking advice from the testing provider on this and bearing in mind the principles on the slide. So, how prevalent has the virus been amongst your employees? Does the workplace setting in itself provide a particular risk of transmission? The risk profile of those in the workplace, and now the government guidance mentions older people or people with underlying health conditions, although I would take that with a slight pinch of salt as the evidence on high-risk groups is constantly evolving, and we now know that it's not just those 2 groups that are thought to be at higher risk. And then finally, the sensitivity of the test you're using, i.e. the likelihood of false negatives, as we've already mentioned. So we've talked about the pros and cons of introducing a testing system, some key points to consider when planning the implementation, and now let's look at what happens when the results come in. So whilst waiting for test results, there's no obligation on the employee to self-isolate unless they have symptoms. Once the results come in, if they are negative, you'll need to ensure that you clearly communicate to the employee what that means. It's still possible that they could have COVID, so they should immediately self-isolate and book an NHS test if they get symptoms. And in the meantime, they need to continue following all of your COVID secure protocols. Then in terms of data protection, you'll need to make sure the results aren't shared any more widely than necessary, that they're only used for your stated purpose, and that you only hold on to them for as long as is necessary for that purpose to make sure you don't undermine all of the good work that you've done on data protection. So in terms of how long to hold on to the test results, that might just be until the next time the employee has a COVID test if you're doing regular testing. What if the results are positive? So first and foremost, the employee must immediately start self-isolating and will be entitled to statutory sick pay and contractual sick pay subject to the usual eligibility requirements. You should inform any of your employees who've been in close contact with that individual that a colleague has had a positive test, but you normally won't need to and shouldn't disclose the name of the employee. Some employers have been doing confirmatory lab-based tests if the initial test was with one of these lateral flow devices to confirm the result, given the risk of false positives and employees unnecessarily self-isolating. If you do choose to do that, obviously there's an extra cost to weigh in, but the employee must continue to self-isolate until the result of the second test is returned. If it does come back negative, they can stop self-isolating at that point. So finally, the light at the end of the tunnel, COVID vaccines. So we only have a few minutes left, and I wanted to just get you thinking about two of the topics that have been coming up for us recently and I think are going to be really interesting. Firstly, can you require employees to have a COVID vaccine? So we're not talking about literally jabbing people's arms against their will, but what about instructing employees to get the vaccine and treating it as a disciplinary offence if they don't? Or could you make it a condition of employment for new starters, or a condition of working in a particular role? Well, at the moment, our view is that you'd be ill-advised to try it. Not even the government has made the vaccine mandatory, and it's highly unlikely to be justified for an employer to try to do so. It might be that once there's more solid evidence around the impact of the vaccine on transmissibility, and once the vaccine's more widely available, it would potentially be more legitimate to look at introducing a policy on this for certain roles, but definitely for the moment, we tend to advise strongly against this. In terms of specific legal risks, in the case of employees with more than 2 years service, as we discussed in relation to testing, you need to tread really carefully to avoid unfair dismissal or constructive dismissal claims. Given that the government hasn't made the vaccine mandatory, that it's a new vaccine and evidence is still emerging, it would be quite hard to effect a fair dismissal on the basis of a refusal to have it. And for all employees, regardless of length of service, and for job applicants, it's worth remembering that some of the reasons for which employees or job applicants may refuse vaccines are linked to protected characteristics under discrimination law. So a policy requiring vaccination could indirectly discriminate against those groups. For example, whilst most of the major religions have spoken out in support of vaccination, there might be some denominations who object on religious grounds, for example, due to the ingredients of a particular vaccine. There may also be employees with physical or mental conditions that amount to disabilities and that mean that the available vaccine isn't suitable for them. I think it will also be fascinating to see the extent to which employees claim that an anti-vax stance is of itself a protected belief under equality legislation. My own view is that it would be really difficult to meet the relevant tests on the basis of that belief, but there have been some notorious and unexpected decisions in this area in the past few years, like the decision that ethical veganism is protected but vegetarianism isn't, for example. I wouldn't be surprised at all if some employees try to run this argument, and it may be something that comes across your desks. So what about just asking employees to tell you if they've been vaccinated? Well, in theory, you can ask if you've got a good reason for needing to know and you can comply with the data protection principles we've talked about earlier. But what would that reason be? Will knowing whether someone's had a vaccine or not change what they're allowed to do or what COVID secure measures you're taking in relation to them? To me, it seems really premature to start distinguishing between groups of employees in that way. And I'm sure many of you will have discrimination alarm bells ringing as soon as we start talking about treating the different groups in different ways, especially when the vaccine isn't currently available to all. But again, this is something that I'm sure lots of employers will be keeping an eye on as the evidence develops, as will we. Finally, throughout this talk, I've referred to a couple of resources that I think are definitely worth a look if you are looking at implementing testing. So I've put the links on the slides there, but you can also find them just on a search engine. It's the Information Commissioner's Office guidance on testing and also the government guidance to employers on workplace testing. So that brings us to the end of this section of the webinar. We'll now go back to Jane for the poll results and we'll pick up some of your questions.
Thanks, Alice. So about just under half of you logged on. So there's about 100 and just over 180 dialed into the webinar. About half of you responded to the poll. Lucy, I don't know if you can share the results, but you can see immediately it's pretty much split straight down the middle of those of you that replied as to whether you're actually testing or not. So that's quite interesting, particularly when you look at the sectors, which we'll come on to in a minute. If you look at the size, it's very evenly spread up to the last two categories, and perhaps not surprisingly, the bulk of testing is going on by the looks of it from this poll in very large employers. And then sector-wise, we're obviously limited on the number of sectors we could put in and break it down. Again, it's fairly evenly spread, although other is the biggest by far. Perhaps that includes different types of manufacturing, possibly. Perhaps not surprisingly, health and care are the highest specific sector. Slightly surprisingly, professional services is the second highest. So that's obviously a snapshot only, but interesting that so many are already testing, actually. I don't know, Alice, if you've got any other comments on that before we go on to the questions.
Yeah, definitely what I was expecting in terms of the size of the employers that are doing testing. But I think given the relative newness of the lateral flow devices, which are much more accessible than having to do lab-based processes, I do wonder if that proportion is going to change. Yeah,
very possibly. Well, as we both said actually already, it's an evolving picture all the time, isn't it, that you have to keep keeping up with.
Yeah, definitely.
Okay, so we've got quite a lot of questions have come through. I'm not sure in the time available we'll get to all of them, but let's give it a go. And if we don't, then we will do our best to follow up with you quickly afterwards. So there's one here, Alice. It says, what do you suggest if an employer does introduce testing or has introduced it already, and a particular employee refuses to have the test?
Okay, yeah, I think that's going to come up probably relatively frequently for lots of employers. So in the case of an individual who refuses to have the test after you've assessed that it's necessary for your workplace, first and foremost, I think it's find out the reason for the refusal. So lots of employees will welcome testing as a measure that is supposed to protect them. So is this more an issue around the logistics, around whether they're getting paid time off to have the test? And could that be resolved with a tweak in the process? But if they're still refusing, I think it's probably then about looking at alternatives that would alleviate the need for testing. So what was it about the risk assessment that made you decide you need to introduce testing? And could there be some amendment to the role, the particular duties that they're doing that would mean that need is alleviated? So you might need 99% of your workforce to be there in person, but could you accommodate this person working from home or in a slightly lower risk or lower contact role? And it's only once you've done all of that that I think you're potentially in the formal process, disciplinary sanction territory. And as I said in the talk, that is just going to be inherently high risk given the nature of what we're talking about. So it should really be a last resort.
Okay, thank you. The next one is, if somebody has had a test through the NHS testing rather than through workplace testing, can you force the employee to share their test result if you're concerned to know what it is before you let them come back to work?
Oh, okay. So with NHS testing, unlike employer asymptomatic testing, you can only get an NHS test in the first place if you have symptoms or if you've been directed by a medical professional to get a test. So if you know that an employee has gone off to get an NHS test, that means they're likely to have COVID symptoms. And if that test result is positive, the employee themselves has a legal obligation to tell you about the result. So I think most employees will volunteer that information, especially when they know that there's a legal obligation on them to do so, and that they themselves can be fined if they don't. If for whatever reason they're not sharing the result though, I think you need to have, again, a conversation with the employee to find out why, make sure they understand their legal obligation, and that the implication of not sharing the result is that you aren't going to know whether it's safe for them to be in the workforce, so you can't let them back to work. I think having had that conversation, most employees should be persuaded to share their results, but ultimately as a medical record, you can't get your hands on that information unless the employee consents to give you it. So it might be that that particular employee has some particular concerns around being able to afford self-isolation. So there may need to be a conversation around what extra support you can give them.
Okay, there's a question that's just popped up, which I think you may already have answered it actually in what you've just said, but the question is, rather than implement a workplace testing program, could it be more beneficial to use a testing hub, an NHS testing hub? I think that's the implication, and create an internal policy to how this program works for the employer.
So I assume by testing hub, that means the NHS test and trace system, which is only available to individuals who have coronavirus symptoms. So for many employers, it will be sufficient to just use that programme. That is the national programme. It's an education piece around ensuring employees go and get those tests if they do have symptoms, but you can't just send employees off to get NHS tests if they're asymptomatic, and your strategy is to try to catch asymptomatic cases at an early stage. I might be misreading that question though, if it's actually about one of these asymptomatic testing pilots. So the government's also part of this Project Moonshot, been partnering with more local authorities and big employers around providing lateral flow tests and training staff on how to manage those, in which case I think that's just a version of what we've been talking about in this talk today. And before agreeing to participate in that, you need to go through all of the questions that I've mentioned in my talk, as though you were procuring private tests.
Sure. So we've got time for one very quick other one. If somebody tests positive, but they're asymptomatic, do you still have to pay SSP?
Yeah, so my reading of the sick pay regs, and I did double check this last night, is that they just say, so in the list of circumstances where someone's entitled to statutory sick pay, which includes things like you've been told to self-isolate by NHS test and trace, one of the items is you've tested positive for coronavirus. It doesn't say you've tested positive after an NHS test. It doesn't say you've tested positive after a PCR test. It just says after you've tested positive. So unless that's amended or there's some other publication that comes out saying otherwise, I think that is the position you should take, is that it's they need to self-isolate. They'll be entitled to sick pay in the usual way.
Okay, thanks, Alice. So we're just about done for time. So thank you very much, Alice, for the presentation and answering those questions. I hope for those of you who are already testing, that's given you some reassurance and not too many things to go away and check. And if you're not doing it already, that it's given you a good framework to approach your risk assessment and decision on how you do it. We are going to be sending you a feedback form once the webinar's finished. It should pop up in your internet browser. Do please fill that in if you have a couple of minutes. We do look at the feedback forms and shape our future sessions around what everybody is looking for. And I hope you'll be able to join us next Tuesday for our next webinar, which is around conducting investigations in the workplace, again, at the moment with the COVID dynamic factored into that. Otherwise, thank you very much for listening, and I hope you enjoy the rest of your day. Thank you. Bye.
Thank you.